petition, my lord. The petitioner is behind bars for more than 1 year, 4 months, my lord. My lord, earlier occasions also, my lord, the matter was left out, my lord. So, my lord, I have informed the other side, the NCB, my lord, they have already filed their reply, my lord, and lordship have heard it at length on 2 days, my lord. So, my lord, may I pray, my lord, to take up this matter as a first item today? And if not,
We don't know. There are a lot of matters and we are sitting only for the 1.5 only.
that's why, my lord.
Let us see, we'll give
At least
the
for my
orders.
interim prayer, my lord, to consider
Just
my interim prayer, my lord.
we'll keep in mind. We'll see. Let us see, because today is a motion. We'll see that the
If
motions
not,
are
my
over
lord,
first.
so tomorrow, my lord, as a first item, my lord.
No. Please wait for let us see how the session goes.
Madam, yes. All right.
W Lordship. Lordship, on 26/9, Lordship, we have filed IF also released the petitioner from the custody, my lord. He's taken under the
All applications for matters for listing to give it to the court master.
Lordship.
Applications for listing, please give it to the court master.
Lordship.
Mention memos.
It is your lordship. I beg to mention item number 22 of today's list.
20.
22. And for the respondents, I have taken the consent of the other side.
This is a review petition.
A review.
And 23 matter. What is the review petition about?
Review is challenging the order of the,
In writ appeal.
yes, in writ appeal dated 23
No, what is the matter about? This is surfacey matter.
surfacey matter regarding one interest which has been imposed
Hmm?
on the bank. The learned single judge has imposed 18% interest on the bank. So that was set aside by the division bench. So against that, they filed this review.
Okay, when do you want?
After vacation, any date, your lordship.
Okay.
Respondent.
Okay, with consent from the learned counsel for the petitioner, Mr. S. Datta, counsel for the respondent, prays for adjournment. Prayer is allowed. List after ensuing vacation on a date to be fixed by the office.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 25. We are led by R.P. Sharma sir. Today he is not out of station. So kindly pass over the matter after vacation.
Okay. Okay, both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List on Thursday would be 3/10/2024.
May it please your lordship. Lordship, I beg to mention item 1 of the daily list, lordship. Lordship, due to some personal difficulties, my senior had to leave the court premises, lordship. Kindly adjourn the matter.
Yes.
It may come up after vacation.
Just wait for your turn. Let the matter be called.
Item number 13, kindly pass over the matter. Nanette Engage Council T and Srinivasan sir is not available today.
I think just wait. Let the matter be called. We'll see then. It's a motion matter.
I beg to mention item number 27, my lord. Maybe upgrade, my lord.
Upgrade, we don't know.
For extension of time, my lord. For appearing before the SP border, my lord.
Okay, we'll try to take it up
My-
at the last item, but we can't upgrade it.
Obliged.
Lordship, I beg to mention item 11 for adjournment. The conducting council due to
11 is a motion matter. Just wait for your turn. Let the matter be called.
Obliged.
Motion matters, we are not adjourning any motion matters.
My lordship, I beg to mention item number 15, my lordship.
15.
Yes, sir.
Okay, 1516, on the prayer made by, also as a representative on the prayer made by learned counsel of the petitioner, list after ensuing whose vacation on a date to be fixed by the office.
My lordship, I also have another prayer, my lordship, of supplementary list item number 28, my lord.
Motion, wait for a turn.
Obliged.
Daily list item 1 for motion.
Lordship,
Yes, on the last occasion, we made a order to provide information to the court about the materials to show that you are daughter of Joanal Abedin.
the petitioner, Lordship.
You filed any affidavit?
Yes, Lordship, we have filed an additional affidavit. We've already filed it, Lordship.
Well, first of all, the English translation may not be totally correct and the information is wrong. The third line, the name is Joanal Ali. This Joanal Ali, you have written as Joanal Abedin Ali. That's not correct. Translation of page 59 is not a correct translation in page 58. Mr. Sharma, am I reading right? Am I reading correctly? It is not very legible. Page 58 and 59.
Yes, lordship.
It's an affidavit file. It's not the main petition.
Oh, yes, yes. Pagination is not missing, lordship.
See the annexure 1 of the affidavit file. Give a copy to him.
Yes, lordship.
Last entry. Is it correct translation? Joanal Abedin
Yes.
is not there.
No,
It's
lordship.
Joanal Ali.
Not correct translation, lordship.
Nothing so and so.
Joinal Ali. Here is Joinal Ali, here Joinal Abedin Ali.
পুত্রের জয়নাল আলীর স্থলত সাবেজান আলী জয়নাল আলী Ali. You must have put that answer, no?
Alir.
Mr.
Yes.
Sharma,
Lordship.
you see the last entry in SMS. Last 4 lines, what is the first word? Within bracket, fifth line, Pitri Joinal.
Joinal Amin. Joinal Ali. Ali.
Ali.
Joinal Ali.
What is the last word? This is not law, Ali. Mr. Taludar, please assist Mr. Sharma.
চক্ৰবিষয়ৰ 26/2018 তাৰিখৰ নামজাৰি নং
হুকুম মতে
মতে
267 আগৰ মাটি উত্তৰাধিকাৰী দখল সূত্ৰে
জয়নাল আলীৰ স্থলত সুবাহান আলী
সুবাহান
পিতৃ জয়নাল
This next word. Journal,
Lordship, perhaps there is some printing mistake. It looks like Amin.
জয়নাল আমিন আৰু
Journal Amin.
yes,
Amin. Tobiron Nessa.
জয়নাল
জয়নাল
আমিন
আলীৰ।
আৰু জহুৰা খাতুন পিতৃ জয়নাল
জয়নাল
here
আলী।
again জয়নাল আলী lordship.
Subsequently, it was written as Ali.
Abdul.
First two are Amin and
Lordship, first two are Amin.
It appears to be Abdin. Some spelling mistake.
Lordship.
Can it be read as Abdin? Abdin.
Lordship. Lordship, there are some words like stolot. That word is also a bit confusing like this. In Assamese typing, sometimes this kind of discrepancies happen, Lordship.
No, we are concerned with that.
This
Name.
particular
Is it,
Last name.
the
Lordship.
name should have been Jainal Abedin Ali.
Lordship.
Now, this word is either it will be Jainal
Abdin
Abdin.
looks
Then
like
Ali is not there.
no,
Lordship.
And in the first
No, he's
line,
not
Ali
there,
is,
Lordship.
Ali is there.
দুইটাতো নাই
Later on, it is written as Ali.
পিতৃ জয়নাল আমিন
Abdin.
Abdin হয়তো নাম আহি আছে।
this looks like Amin lordship. Abdin কেনেকে হ'ব
22 Later on, it is Ali, no?
We're issuing a notice, there's some,
Yes,
some semblance of
Later on,
notice
it
there.
is written as Ali. Later on,
And later on Ali,
Later-
but,
after two,
but both names are found. Ali is also there, Abdin is also there.
Lordship.
Your name?
Lordship, AK Choppy appearing on behalf of G Borderler.
Huh?
AK Choppy appearing on behalf of G Borderler.
AK,
Choppy,
CHOP,
HI.
HI. Learned Counsel appearing on behalf of Mr. G. Bordole, Counsel for the petitioner. Also heard. For Union of India?
Nobody here.
Okay. Mr. G. Sharma, Learned Standing Counsel for the
2 and 6 lordship.
FT matters, representing respondent number 2 and 3,
6 lordship.
2 and 6. 3 also?
No, 3 will appear by him lordship.
It's fully.
H
Oh, okay. Mr. Kulin and Counsel for No, you're for election commission. No, no. Then number 3 is Superintendent of Police, border. You will be appearing.
Yeah, yes, Lord.
2, 3, 2 and 3. Then
Yes,
Mr.
Lord.
Mr. R.K. Talukdar, London Government Advocate, appearing for respondent number 4.
Respondent number 5, Lordship.
Respondent number 5. 5 is State Coordinator.
There is some mismatch.
Some mismatch.
There is some
Lordship,
mismatch
in our
in Lordship.
petition.
In our copy, it is
No, seriously, go by it. You correct it because here it is corrected. 1, 2, 3, 4, 5,
Lordship.
6.
Lordship.
So Deputy Commissioner will be appearing for Deputy Commissioner.
I'll be appearing, Lordship.
And 6 is Mr. Kulia, appearing on behalf of Mr. Ali, counsel for the respondent number 6.
7 years.
Not to correct it again. Okay.
Next, appears to be a discrepancy in the hearing of respondents in the second copy of this writ petition, the second judge's copy of the writ petition, as well as in the copies served on the shall the learned counsel for the petitioner shall do the necessary correction in the cost title. Next paragraph. By filing this application under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 17/11/2022, page 2. Thereby declaring her to be a foreigner of post 25/3/1971 stream. Next. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned BSGI in respect of respondent numbers 1 and 6 and to the learned appearing counsel for the state respondent numbers 2 to 5 within 2 days. Next, let the records be called for from the Foreigners Tribunal number 11, Bopeta. The records of FT case number 1669 of 2017 we called from the Foreigners Tribunal 11th, Bopeta. Next, the learned counsel for the petitioner has paid for interim relief. Heard both sides on the all sides on the prayer for interim relief. You give the bail 5,000 rupees to the satisfaction of his Superintendent of Police within bracket border Bopeta. Next, the petitioner shall appear before the SP border within.
It is a bunch of. Hang on. Study. Maybe.
Within 14/10/2024. Next list on receipt of the records from the tribunal.
Item 2.
May I lordship.
Yes,
Last occasion, my lord, my learned counsel, Sharma took time to obtain the
yes,
inquiry
we got a
report.
report from the SP border. Mr. Sharma,
Lordship. I want to say, Lordship, we fix it immediately after vacation or Lordship.
no,
Last-
you look at this order.
Yes, Lordship.
24/8.
Yes,
He informed me, Lordship, by at present I don't have that order, Lordship. That report, Lordship.
Okay.
Otherwise, Lordship may issue notice at this case, Lordship. I think
No,
notice
in
was-
fact, if I think the order is very clear. If the petitioner is not the proceedee, there's no
Yes.
issue of issuing a
Lordship, I will
no
bring the
point of
report.
issuing a notice. Okay, Mr. A.M. Ahmed, counsel for the petitioner is present. Mr. G. Sharma, learned standing counsel for the Foreigners Tribunal. Prays that the matter be taken up after ensuing Durga Puja vacation, so as to enable him to obtain and produce a report from the superintendent of police within bracket border, Barpeta, as directed by this code by order dated 24/8/2023 and reiterated in the order dated 15/9/2023. Next paragraph. The learned standing counsel for the FT shall send a downloaded copy of this order to the superintendent of police within bracket border. Next paragraph. List after ensuing Durga Puja vacation on a date to be fixed by the office.
my lord, my simple prayer, my lord. In the meantime, some protection, my lord. There is no interim order, my lord. A lady, my lord, that's why my lord, I'm saying. At least, my lord, not to take any coercive action, that line may be put in the,
Nothing was reported,
my lord.
not to be deported.
No, I did not to be deported means the police may arrest me. Lord.
Nothing was happening.
the-
Lordship. Till that, Lord.
Till the next date of listing. As an entry measure. That bill 5,000 rupees to the satisfaction of
SP Borpeta.
SP border,
Borpeta.
Barpeta. The same will appear within 10 days, within 14/10/2024. Those conditions will be there, iris of the eyes and all, those conditions will be there.
Oh, bless.
Item 3.
I have challenged the order dated 30/11/2023, my lord. This is the case, my lord, 102, my lord. My lord, the petitioner's others parents' name, my lord, is appeared, my lord, in the voter list of 1966 and 70, my lord.
Just now. Page,
Is my lord. 23 onwards. 23 is the type copy, my lord. Mozu Sheikh,
who are they?
they are the parents of the petitioner, my lord.
Mozu Sheikh is the father.
Father, my lord. Subsequently, Mujibur Rahman, my lord. Mujibur Munshi, my lord.
That will come later. Now, this Sajin Bibi is the mother.
Shadin Bibi is mother, Shahatan Bibi. And 70 also, my lord. Mazu Sheikh, Shadin Bibi, my lord. The petitioner's name, my lord, has been recorded in the voter list, my lord.
Just now. Yes, your name appeared in the voter list of
And 1989, my lord. For the first time. 89 in the
page,
house of her matrimonial house, my lord.
page.
Page, my lord, 56, my lord.
Page number
Page number 56, my lord.
56.
56, my lord. Serial number 611, my lord. Rohima Khatun. Along with her husband and her in-laws, my lord.
56. There's
56.
no Rahima Begum.
Rohima Khatun.
57. Huh.
Hashmut Ali is the husband of the British.
There's no Hasmat Ali.
Hashmut Ali's name is 607, my lord.
From Hasom Ali.
Hashmut Ali.
No. C57 against Rohima Khatun, Hasim Ali.
Tamali.
Actually, my lord, it should be a Hashmut Ali, my lord. 607, my lord, Hashmut Ali. He is the husband, my lord.
7.
607. Hashmut Ali. But against Rahima Khatun, Hasham Ali. Wrongly reported, my lord. Please. Next place also, my lord, 97 also, my lord. Hashmut Ali, Rahima Bibi, my lord. Page number 59, my lord.
But how do you connect with your father, parents?
Kabin Nama is there, my lord.
Where
Kabin
is
Nama
that?
is there, my lord. His elder brother has been examined as DW2, my lord.
Where is that? Kabin Nama?
Kabin Nama is a place, my lord. Kabin Nama is a place 49, my lord.
Kabin Nama is not mentioned in your written statement.
Yes, mentioned, my lord. And the Qazi was also examined.
No, page 75 is a written statement.
Yes, my lord.
Where have you introduced that document?
Page 75, my lord. Hmm.
This is not there. In your evidence on affidavit, have you introduced that?
Yes, my lord. That's very nice.
Kabin Nama is there, exhibit E,
Exhibit
page 82.
E. my lord. And Qazi also examined as DW4, my lord.
Where is that Kabin Nama?
Kabin Nama is place 49, my lord. First, name of Brahmanat Hashmut Ali. Serial number 3, name of father and Rohima Bibi, daughter of Mujibur Rahman. Arwa Futa.
Finding yes is 110. First, the marriage is registered on.
Mojibur Munshi and Maju Sheikh cannot be same and one person, Lordship.
Maju Sheikh, same
Lordship,
person.
father's name different, Lordship.
No.
Age discrepancy here, third year, Lordship.
Yeah, some.
Here, Maju Sheikh, son of Kalu Sheikh in 1956 voter list.
Yes.
And
Your
Lordship,
father's and mother's name completely changed.
yes,
Yes,
Lordship.
Lordship. Maju Sheikh subsequently became Mujibur Rahman, but his father's name
Name
is
of the mother?
Kalu Sheikh.
The name of the mother,
Mother's Shazin Bibi, actually, my lord,
then
Sukurzan Nesa, my lord, actually.
Then how can it be one person? Where
Same
it
person,
is
my
two?
lord, in the same village, my lord.
No,
Same house, same
is a
village,
different
village.
issue. You'll have to make all
He
these
is, my
statements.
lord.
And the Kabin Nama,
Mujibur Rahman.
Mojibur Rahman.
Kabin Nama has been, how it has been appreciated. Have you seen the evidence?
Yes, my lord. The record has been received, my lord. You can put your record.
Your Kazi has says it is not within the jurisdiction.
That may be, my lord, but
Then
marriage can be done, my lord, in Gwalpar district's person, my lord, his marriage may be solemnized at Guwahati also, my lord.
can the office register the date of marriage is struck out. In the register, date of marriage was struck out. In the office register.
That is why, my lord, the Qazi has been examined, my lord.
No, you see, it is there in the
Yes.
opinion itself.
Yes.
It is there, it is written in the
Qazi
opinion.
appeared before the learned tribunal, my lord, and deposed on oath, my lord.
And then the date of marriage. of
That is the best thing. He deposed on oath. That is the best thing.
Yes, my lord.
You look at page 110, how the appreciation is made. He has said on oath that the name has been struck off.
Secretary also appeared, my lord.
No.
Both of them gave two different dates for the marriage. Same marriage.
Lordship, moreover, he has also deposed that it was not solemnized as per law.
Correct.
That
That's
he has
that's
also
right.
deposed.
So that is the good part of his deposition.
Yes, my lord.
Now, how do you overcome that?
That cannot be the fault of the petitioner, my lord, as because, my lord, the petitioner is an illiterate person, my lord.
Nothing for it, knowledge.
No, you have not re-examined him. He is your witness.
Yes.
He was not brought by the state. You brought him.
My humble submission before your lordship, my lord, as the record has been received, my lord, let the matter be fixed for hearing, my lord. In the meantime, he may be protected, she may be protected, my lord.
No, we are hearing it.
Otherwise, my lord, she became the first voter, my lord, in the year 1989, my lord. Right from 1989, my lord, till date, my lord, her name has been duly recorded in the voter list, my lord, without any adverse remark.
There is a record of a person by that name, whether that person and the proceedee is one and the same person.
That person is the same person, my lord. That is why, my lord, she appeared before the learned tribunal upon receiving a notice, my lord. If she is not that person, my lord,
The
she
opinion is
would-
before,
would-
the opinion of the tribunal is before you.
Yes, sir.
You tell us where the infirmity has occurred. Which part of the order? According to
Learned
you.
tribunal opined that the Maju Sheikh and Mujibur Rahman cannot be the same person, my lord. My stand is that, my submission is that Maju Sheikh and Mujibur Rahman is the one and same person, my lord. As because, my lord, Maju Sheikh's father's name is Kalu Sheikh village Haruaputa, same house number, my lord. And Mujibur Rahman's father's name is Kalur Sheikh, my lord. In the same village, same house number, my lord.
Late Kalu Lordship.
Yes,
not
late
Kalu
Kalu.
Sheikh.
Late
And
Kalu. Late Kalu. In
but here,
1960,
late is not here.
1960
In
also, my lord, late Kalu.
1979, late is not here, Lordship.
1960 and 70 also, my lord, late Kalu. Kalu.
Who is Haidar Ali?
Hoiber Ali.
Haidar.
Haidar Ali, my lord.
Who is he?
Haidar Ali in Haidar Ali. My lord. In 85 Student Abdul Mannab is the elder brother, my lord. Haidar's name is there, my lord. Haidar. Hoiber Rahman. In the draft NRC also, my lord, her name has been recorded, my lord. Showing her father's name as Mujibur Rahman. It's at page, my lord, 66, my lord.
Father.
Oh, did you-
Wait.
Mhm. It's not unlike it. Every village is very negative. Like a very innocent. Huh?
Therefore, the finding. Therefore, the finding by the tribunal.
Strike. I get it.
Probably 9. Bihar 9 will get it.
Like I got like
Oh,
like I got a Bharat registered.
Hmm.
It would basically solemnized on one level, registered on one level.
yeah, the key to the striking.
That's it. So, mostly. I'm working. The minimum 6 months can be registered. Spend 10 minutes.
Therefore, instead of Pulo, And Mr. Sharma,
Lordship.
I think in the order, we have noticed something which is not there in the records. If you come to page 110, towards the end, second last line, in their office,
110.
110,
Their office issue register date of merit is.
second last line from the bottom.
Date of merit. So. this is list of-
In their office issue register. Have you found it?
And then
In their office. 110.
Hmm.
In their office,
yes. Indian office issue. Indian office issue register date of marriage is strike out at the column of year and date of marriage to create a serious doubt about the genuineness of the said document.
This apparently is not reflected from the evidence of the Qazi.
Lord,
But one thing is certain that Qazi has admitted that it was not within their jurisdiction.
yes, Lordship.
We'll issue notice at this stage then.
Lordship.
Will do. Mr. S. Islam, Learned Counsel for the Petitioner. Mr. Anyone for union?
Mr. K. Parasar was something like us.
Mr. K. Parasar representing respondent 1. Mr. K. Cooley for respondent number 2. H. Cooley, sorry. Mr. G. Sharma for respondent number 3. And 6. And Mr. Talukdar for respondent number 5. Pursuant to the earlier order passed, the trial court records have been requisitioned. Stop. We have perused the trial court records. And at this stage, we're inclined to issue notice. So accordingly, let notice be issued. Returnable 4 weeks. Since the respondents have already entered appearances, notices are waived, however, extra copies be furnished. Steps on respondent number. Respondent number 4 by registered post AD within 1 week from today. Until further orders, if the petitioner appears before the SP border Gwalpara and furnishes the bail bond of rupees 10,000 with 2 local securities of like amount, petitioner shall be allowed to remain on bail and shall not be deported out of the country. And when the petitioner appears, the biometrics and fingerprint, etc., will be recorded. Matter to be listed for admission after the returnable date by the registry.
Item 4.
Yes.
Interesting. No, but this is also the same. Yes.
I filed this application, this petition, to challenge the order dated 20 25/1/14 and 24 and 28/3/24, by which the listed witness of the petitioner prayed for the allowing to adduce evidence that was rejected. And furthermore, the entire cross-examination was done by the learned tribunal.
Where is the order?
Order at page 97, translated copy, order at 28/3. Eighty-one and 97 page. We also have called for the relief eligibility certificate from the sub-divisional officer Basirghat. And one report was came that there is no such record. But I want to prove that they have no any record, because when we have personally can go there and ask the whether what are the records with them, but they said that we have no any record.
What records do you want?
And certificate issued to the father of the petitioner. Grandfather of the father. Relief eligibility certificate. Have annexed the relief eligibility certificate at page 142.
Evidence flows from the. Was there any list of witnesses furnished?
You have furnished.
Where is that?
It is page 20. Type copy is at page 20 and 21 is the copy. Handwritten copy.
So where is your mother here?
Here in the Guwahati.
No, in the
Okay,
list.
sorry.
In the list.
In the list,
First.
one number. Karuna Thikadar,
Number 1.
number 1.
Whose name is in the list of witness? The list of names. Yes, Mr. Sharma. Mr. Payeng.
Yes, sir.
You come to page number. Where is that list of witness?
Page 20.
Page 20.
This
You come to page 20.
yes, technical part, this can be allowed. I think we are not on so technical issues.
Right.
We need only this matter. This can
No,
be
because
allowed.
the name of the mother already is
Yes,
there.
this can be allowed probably for that. We have no objection. on that.
The record of the recognized.
Huh?
Record of the relief eligibility certificate, which I called for, that was not submitted, that they have no any record. This
is a
record is not found.
That we don't know that you take steps before the tribunal.
Yeah, I have submitted there, but that was rejected. My application was rejected.
Where is that action order?
The order dated 28/3/24.
Page number?
Page number. Page number 97 to 102. Order dated 28/3.
Where is that report? The report is here.
The report is that they have no any such a record found in the name of Governor,
I know, but where is
ঠিক
that
আছে।
report? Where is that communication letter?
we have not filed the report. But technically report, LCR is here. LCR is also.
They revealed that they are not likely. For the petition has also been known.
month. That's
Petition para देगा ना दिया था petition का दिया था जब आपको भी होने जरूरी है कि जस्टिस सर्विस जब चली गया तो कोई इंफॉर्मेशन एक बार पोस्ट लिया था टेस्ट लिया था टेस्ट लेने के बाद में बोला petition is one count for page number.
well.
Sending you the LCR.
Yes.
I put a pink flag there. Four pages, just go through it.
In this case, the entire procedures are done by
No,
the
you see, you are doing a trial, you do not know how to handle the trial. That is the difficulty. You see this notice. Come to next page. This is certificate.
Yes.
Correct?
Yes.
Certificate is issued by the certificate officer. Correct? Now come to first page again. Notice is issued to SDO.
Subdivisional.
Now let us say that a registration officer in Guwahati has given a certificate. Now you issue a notice to the SDO. What will SDO do?
I don't know where from the, but in the notice, it has also come the certificate of.
No, but you look,
Yes.
this is the one.
Yes.
Come to next page again. Yes. Now you see he puts a full stop there.
Yes.
After that he says SDO has not issued that. He can't verify. So SDO was never intended to be called. It is the registering authority. Now who according to you is the registering authority? Now if we ask for that registering authority, let us say in context of Guwahati, who will be the person who will having that record?
Yes, they've sent the someone again and again to the, my lord, the subdivisional officer. He refused it.
No, I understand, but in context, I'm just trying to understand. We are just trying to understand.
Yes.
If let us say the registering authority Guwahati has issued a registration certificate. At that time, maybe he was SDO. He put the seal of SDO. So if I have to call the records from Guwahati, where
What
will
is
I
that?
address it?
From registration authority, registering authority only.
Registration officer.
Yes.
So that is a difficulty. You do not know how to issue a notice. You issued a notice to a wrong person, and this reply has come.
The reply has says, my lord, my lord, in fact, on their prayer, my lord, the tribunal has sent 2-3 times. And they've refused to come for 2-3
No, but
times.
the tribunal is arrived at a wrong conclusion. They say that their registration is not there. That's not the issue. The notice is gone to SDO. SDO says I don't maintain that record. That record is maintained by a registration officer. You do whatever you want. We can only. You please make it clear. You make it clear from where do you want to call? Because we can't make out anything. We need to reject a seller. Rejected. Rejected. And then you can request rejection, you can take appropriate steps.
So we remand the matter.
Yes.
Mr. Pai,
Well, for mother, your lordship may direct, mother can be allowed. The other part, because they misdirected the.
no, that's what we'll say.
Yes.
We'll leave it to them.
Yes, that is
If they want to
up to
file,
the,
they'll file.
my lord, jurisdiction of the tribunal. My lord, the mother can be allowed. We have.
You have to file, I don't know why you call this SDO.
SDO has
He's not
already
the
denied.
appropriate authority.
Your Honor, my lord, the actually my friend will elaborate it. He was the person he was handling.
Yes, yes. Why did you issue notice on the SDO?
May I please, your lordship, while the call of witness was going on, we have taken steps in two modes. One is the postal mode, other is the dusty survey
On whom?
on the certificate officer. So after reaching the very destination of the office, we came to learn that SDO himself was the registration officer in that then period. At right now position, there is no any certificate officer. So what has happened? We accordingly we have intimate the tribunal that so and so is the fact. But another thing is that, Your Lordship, when we reached there, then they with the dusty service, they refused to take our dusty service. Reasoning, and they have stated the reason, we are not maintaining anything. How could we be able to give you that this data and all? And secondary matter is that, Your Lordship,
You
the
have,
tribunal.
you have remedies under other statutes to find out what information you require. You take recourse to these, what orders
We
do
have
you want
also
us to
filed
file?
RTI, but they are not appearing with any reply.
Then there is
So,
a provision, the
Yes,
remedy available under
yes,
this
we
statute.
will be going in next week to file the appeal,
You
Your
do
Lordship.
whatever you
That,
will.
one more noticeable thing is that, Your Lordship, is the tribunal having authority to the cross as the adverse party. Because in Evidence Act,
No, we are now putting a question to you in respect of notices issued to the SDO, only to that extent. So far as examination of your mother is concerned, we find that she is already named in the list of witnesses. So therefore, perhaps the finding arrived at by the tribunal may not be correct. So we will pass necessary order permitting you to cross-examine your witness as per the list. But so far as the notice part is concerned, that you decide on whom the notice is to be issued, that's all. No? Mr. Pai?
Yes.
Heard?
Lordship, till date, the order dated 28 and 25/1, 24. It's on page number 81. Sorry, Your Lordship, the cross examination or DW 1, 2, and 3 from page number 66. In the very first column, the tribunal within bracket had quoted question puts by the tribunal. And later on,
We are not examining that.
okay.
Are you challenging that part?
Pardon, Your Lordship?
Are you challenging the cross-examination in this repetition? You're not challenging that.
Your prayers are from page 16, 15 onwards. Kindly have a look at the prayers made. You are praying for expunging the cross-examination. Have you filed any application before the tribunal to that extent?
Yes, Your Lordship. The very day WS was submitted, the learned tribunal has taken the cross on the very same day. The evidence.
Where is the cross by the tribunal?
It's on page 66. Questions put by tribunal. And my prayer was rejected on that very ground only, stated that already cross was done.
So what was your prayer? For examining your
For
mother?
examining my mother.
So why are you aggrieved with this page 66 order? Do you have that book, that
Foreigner's order.
foreigner's order?
Foreigners Act. Wait.
No, it one.
The foreign has ordered. But this is for donors, different of this. Please send back the trial court record. Evidence. My God. The first one was a legal prosecutor.
There was no evidence on affidavit file.
Something is wrong. The order sheet says 28/8/2023. Proceeding is present. He has submitted his evidence on affidavit at DW1.
We
Then
have
after
filed.
DW1, if the cross examination is made, what is wrong?
Look, can tribunal do the cross examination? That's the
Why not?
question, your lordship.
The power of the
137 says that cross examination to be done by the adverse party, not by the court.
Hmm.
If court plays the role of the adverse party, that his interest and the adverse party's interest would be the same.
Evidence.
165 power of the court to ask questions.
Ask question, but not to do the cross examination. Your lordship, 137 says, Evidence Act, cross examination. The examination of a witness by the adverse party shall be called is cross examination. So the can chair play the role of adverse party?
There are judgments here where the strict rule of evidence is not applicable in so far as the tribunal is concerned.
Lordship, what has happened? We
What
was
you are,
going
what
so.
you are arguing is what would normally be the process in a trial. We are before a special tribunal set up under the provisions of an
I
act.
am not with so much knowledge, your lordship, but I am with little knowledge, and with that sum of little knowledge, I am just raising a question.
No, no,
Does
no,
law
no, no,
permit?
no, therefore, we want you to gain more knowledge. So that with this little knowledge, you don't raise questions which are self-defeating, because there are judgments of the division bench to that effect.
But in concern to 165, as per I have made research, but 137 clearly says that it is role of the adverse party, your lordship.
What we are saying is, there are judgments of this court to say that the tribunal has the power to ask questions. Now, what is the order here? See, you come to page 68.
Lordship.
It begins with questions put by tribunal.
Tribunal.
It doesn't say cross-examination.
But order reveals, your lordship, who has done the cross-examination then? Order reveals, kindly peruse page 97. It's the typed copy, translated copy, typed copy, sorry. The last two lines starts. Opposite party files another petition. Page 97, Annexure 8, lordship. Opposite party filed another petition stating that he wants to adduce evidence of Karuna Tikadar, who is mother as her name in the listed witness dated so and so. On 15/12/23. That date is very crucial, your lordship. 15/12/23, when
Yes.
opposite party and two of family member were cross-examined. So if it is the questions put by the tribunal, not the cross, then who has done the cross-examination? If it is not cross, who has done the cross-examination? And onto that footing, my prayer was allowed, cancelled, rejected.
But that part we are allowing, my lord. We are not saying the mother may not be examined.
No,
That
I
is
am on
one-
the footing of the cross-examination.
No, that's why.
If that is not the
Secondly, that is
cross-examination, who has done the
nomenclature, my lord. Your
cross-examination?
lordship may kindly see if my
No,
lord.
that is a
Nomenclature of the cross-examination. If your lordship may kindly see this 60.
No cross-examination has been made, your lordship.
My lord, my submission is that we are actually, I was not going to the technicality of so much, my lord.
No, you're not getting it. You see, who does a cross-examination?
Yes.
State does it?
The state may not do, my lord.
No, we are not on that.
Yes,
Ideally, state should do it.
yes.
So the state is not coming forward that we lost a right of cross-examination. You are happy with it. Correct. So far as his prayer is concerned, we are allowing the mother to be adduced.
Yes.
You don't want a cross-examination.
it's up to you.
Cross-
Up to
my-
you.
Yes, that is up to my lord state if state
It's
may
up to you.
cross-examine.
He's
Yes.
cross-examined, but
We are
we
not
allowing
on that,
it.
my lord. That's why I'm saying,
Petitioner is not suffering any prejudice
yes,
with that.
I don't know.
The
why-
other orders don't reveal that there was a cross-examination.
Yes, my lord,
Except for this,
except for that line,
Page
my lord,
98.
last order, impugn order.
19
If your
days
lordship
have-
may kindly say, if we go on super technicalities, in page 68, there is
we are
no,
anyways interfering with this order. That's
yes, page 68, there is no my lord line that this is a cross-examination. But he typed out in page 66,
So that's okay.
the
If-
type
when
copy of
state is not
cross-examination.
wanting-
attitude. Where from you
State
got
is
this
not
line? my
asserting the right to cross-examine.
The order says so.
lord? No, in page 68,
Order dated 20
he's typing out the cross-examination of
Words,
the.
the original order says he was examined.
Yes,
Hmm.
where is
Cross-examine will not be there. That's why we
where
are
is the
interfering.
line of cross-examination?
Heard, learned counsel, the parties. You're Mr.
R.K. Gupta.
R.K. Gupta, counsel. And Mr. Moore appearing to the petitioner, Mr. S.S. Mr. K.K. Porakor for Union of India, Mr. Dipayeng for respondent number 2 and 3, Mr. Hazarika for respondent number 4 and 6. Mr. Payeng for also respondent number 5.
Yes.
And Mr. Cooley for respondent number 8. None represents respondent number 7. So this writ petition is directed, is filed, putting to challenge the order dated 28/3/2024, passed by the learned member, Foreigners Tribunal number 1, Kamrup Metro, Guwahati, in FT case number 456 of 2014. Stop. By the said order, the prayer of the petitioner to adduce evidence of his mother, one, Srimati Karuna Thikadar, was rejected. Stop. The tribunal held that on an earlier date, that is 15/12/2023, the opposite party and 2 of his family members were cross-examined and discharged. And consequently, the prayer of the petitioner to examine his mother was rejected. Stop. The further prayer of the petitioner, it was further ordered it was further ordered by the tribunal, i.e. the said order, that in view of a report having been received from the subdivisional officer Basir Hat, within bracket in the state of West Bengal, that no record regarding relief eligibility certificate is found in the name of Bhagirat Thikadar, within bracket, projected father of the writ petitioner, Kumar. The tribunal declined to issue any further notice to the subdivisional officer Basir Hat. Stop. Well, learned counsel for the petitioner submits that the petitioner as a proceeding submitted his list of witnesses as far back as 28/03/2023 before the tribunal. In the proceedings which are initiated against the present petitioner. Stop. The list of witnesses contains the names of 4 witnesses. Stop. Witness number 1 reflects the name of his mother, namely Srimati Karuna Thikadar. Stop. It is submitted that in view of the list of witnesses having been submitted as far back as 28/08/2023, the conclusion of the tribunal in rejecting his petition seeking permission to adduce evidence by his mother that all witnesses were examined and discharged, and that the petitioner never mentioned that his mother shall be allowed to adduce evidence as a witness is contrary to the records available before the tribunal. Stop. The further submission of the council is that in view of such position as is evident from the records, the rejection of the prayer of the petitioner to examine his mother is required to be interfered with, and the petitioner be permitted to examine his mother before the tribunal. Stop. It is also submitted that the finding of the tribunal that in view of the report submitted by the subdivisional officer Basirhat, that there is no record regarding relief eligibility certificate found in the name of Bhagirath Tikadar, within bracket, projected father of the petitioner, bracket closed, is also required to be interfered with in view of the fact that the certificate has already been placed before the tribunal as exhibit, and in support of the said exhibit, evidence is required to be adduced by the officer / the authority who is the custodian of the records relating to the said certificate. Stop. As such, the prayer of the petitioner to summon the witness from the concerned department in support of, to adduce evidence in support of the said exhibit, namely the relief eligibility certificate issued in the name of Sri Bhagirath Tikadar Omar, is required to be permitted, and this court should appropriately pass appropriate orders in this regard. By earlier order dated 3/6/2024, the tribunal records have been called for, and the same have been received. Stop. Mr. Payeng, Learned Counsel, appearing for the state respondents, State Home Department, submits that what is your submission, Mr. Payeng? That
My lord, your lordship may record my objection that it is, there is no illegality on the part of the
submits that there is no illegality in the order, and therefore the writ petition needs to be rejected, and the proceedings be permitted to be carried on. So, there is one more submission. There's one more submission of the petitioner. Please record it. The petitioner has also urged before this court that the impugned order dated 28/03/2024 reflects that cross-examination of the witnesses were completed, and which is the reason why the prayer for examining the mother of the petitioner as a witness was rejected. Stop. It is submitted that in terms of the Evidence Act, as per the provisions of the Evidence Act, it is the adverse party who has to examine, who has to cross-examine. Stop. However, in the present proceedings, there was no cross-examination undertaken by the opposite side / the state. The tribunal merely put questions to the witnesses. Stop. Under such circumstances, the conclusion of the tribunal that the witnesses have been discharged pursuant to examination and cross-examination is belied by the records. Correct. Then Mr. Payeng raises his objection and says there is no dispute and there is no infirmity and the order ought not to be interfered with. Better. Learned counsels for the parties have been heard. The pleadings on record are carefully perused. The tribunal records called for and placed before this court has also been carefully perused. From the records, it is seen that there is a list of witness which was furnished, which was filed before the tribunal as far back as 28/8/2023, showing the names of 4 witnesses to be examined on behalf of the writ petitioner in support of his case. 5 witnesses. Five witnesses, including the petition. So, under such circumstances, the said petition is also available in the tribunal records. Under such circumstances, the conclusion or the finding of the tribunal that the petitioner never mentioned before the tribunal that his mother should be allowed to adduce evidence as a witness appears to be contrary to the records. So, once the list of witnesses are filed before the tribunal, it reflects the intention of the parties to call the witnesses named therein for examination in support of the case projected. Stop. Insofar as the prayer for calling issuance of a notice to the authority who is the custodian of the records for the relief eligibility certificate issued in the name of Bhagirat Thikadar, it is seen that a relief eligibility certificate in the name of so-and-so, as well as the certificate of registration issued in the name of Bhagirat Thikadar, it is seen that notices were issued to the registering authority who to the subdivisional officer, right?
Yes.
Was issued to
Subdivisional officer.
subdivisional officer,
Subdivision.
which was the registering authority at that time.
No, your lordship. At that very time, the certificate officer used to happen. But now all the records are within the domain of the SDO. That is why steps was taken in his name.
FRRO is the SP, I think. Was insofar as the notice issued to the certificate officer,
Your lordship, on 3 occasions, we have taken steps in the name of the registration officer.
certificate officer notices were issued and notices were issued in the name of the subdivisional officer, Barrackpur, West Bengal, who is shown to be also the certificate officer, Citizens Registration Authority, Barrackpur Division. Stop. The foreigners within bracket tribunals order 1964 clearly lays down the powers to be exercised by the foreigners tribunal under clause 4. Stop. Under the said clause, one of the powers ascribed to the foreigners tribunal is for summoning and enforcing the attendance of any person and examining him or her on oath. Stop. The tribunal also has a power for issuance of warrant of arrest if the need so arises. Stop. Under such circumstances, where an application is made for summoning a witness for present in support of evidence to be adduced in favor of the any exhibit presented by the proceeding, the tribunal is expected to issue necessary summons to the concerned authority. Stop. The order of the tribunal declining to issue a summons in view of a certificate issued by the registering authority / the subdivisional officer Basir Haq that no records are available, will not, in the opinion of the court, satisfy the requirement of clause 4 of the Foreigners Within Bracket Tribunals Order 1964. Stop. The further submission of the counsel for the petitioner that no cross-examination was undertaken of the witnesses, and therefore the examination, therefore the questions put to the witnesses by the tribunal, which are treated to be cross-examination by the tribunal, and the same being contrary to the provisions of the Evidence Act, these said within courts cross-examination made by the Foreigners Tribunal be expunged, does not merit consideration. Stop. We have carefully perused the tribunal reports, and in the earlier orders, the tribunal has recorded that the examination of the witnesses have been complete. Stop. Insofar as the documents enclosed to the writ petition also reflects that questions were put by the tribunal to the petitioner on 15 December 2023. Stop. Nowhere in the earlier orders or in the questions put by the tribunal is there any indication or reference that it is a cross-examination. Stop. Under such circumstances, merely because the term within quotes cross-examination finds place in the order dated so and so, we do not find any grounds to accept the submissions of the writ petitioner that these questions put by the tribunal are treated to be cross-examination and therefore are required to be examined, expunged. Stop. Para. Having considered the materials available in the tribunal records, as well as upon due consideration of the rival submissions, this court is of the view that the order impugned in the present writ petition dated 28/3/2024 having considered the submissions and tribunal records, this court would like to pass the following orders in respect of the orders impugned dated 28/3/2024 in the present writ petition. Para. The matter is remanded back to the tribunal for proceeding with the reference expeditiously as provided for under the Foreigners Act 1946, read with foreigners within bracket tribunals order 1946, read with foreigners within bracket tribunals for Assam bracket close order 2006. Stop.
Well, 2006 may not be included. 2006 is no more. 90.
Certain amendments were there, therefore we thought you don't want.
No, 2006 is set aside.
Set aside.
Yes. But that book, probably it is not mentioned. After the second, my lord, the Sabananda, that has been set aside.
Okay, then strike out 2006. The tribunal will permit the proceedee to call for and examine any witness, including his mother, left in the list of witnesses presented before the tribunal, filed on 28/08/2023. Stop. Insofar as the notices being required to be issued to the authority who is the custodian of the relevant records relating to the relief eligibility certificate and the registration certificate shown to have been issued in the name of Bhagirat Thikadar within bracket projected father of the proceedee bracket closed, comma. The tribunal will pass appropriate orders upon such applications being filed by the proceedee / the writ petitioner. We permit the petitioner to file necessary applications and before the tribunal accordingly. Stop. Insofar as the prayer for expunging the cross-examination of the witnesses is concerned, the same is rejected since there was no cross-examination and only questions put by the tribunal. Stop. The reference of the term within court's cross-examination in the impugned order dated 28/3/2024 cannot be accepted for the purposes of the present proceeding to be cross-examination of the witnesses. Stop. Such term perhaps was used by the tribunal as a matter of oversight. Stop. The state led by the government leader may take steps to cross-examine any or all of the witnesses if permitted under the procedure of law. Stop. The impugned order dated so and so, therefore stands interfered with in terms of the discussions as above. The matter is remanded back to the tribunal to proceed in the matter as expeditiously as possible as provided under the so and so act read with the tribunal order of 1946. LCA to be sent back forthwith. Writ petition accordingly stand the disposal.
Your
We direct
lordship
the
may
petitioner to appear before the tribunal
fix it at October.
on 23rd October. Before the
May it be
tribunal.
after October, your lordship,
No. 23rd October.
because
1 month.
I'm going out.
You are going out, we are directing the proceeding to appear. That's all. You have to make arrangements.
You want this examination made by the court to be expunged? Are you praying that the examination made by the tribunal should be expunged? Although you have not made a written prayer, we are asking you. You want it to be expunged?
Questions that court has taken.
No, we are asking you, do you want, although you have not prayed in the relief, do you want the examination by the tribunal to be expunged? We're just asking you a question.
I have prayed in the writ petition. In the writ petition, I have prayed.
You have prayed that.
Wait for expansion of the cross-examination.
No, there you have made a prayer for cross-examination, not the examination by the tribunal. So we are asking you.
No, examination, I cannot, I'm not putting the question that examination in chief is to be expunged.
Not examination chief, examination by the tribunal.
Opposing the cause.
The question put by the tribunal, you want that to be expunged? Yes.
Yes, we have filed that.
We are for the second time asking you, the questions put by the tribunal to all the three witnesses, you want it to be expunged?
No. Not required.
Hmm?
Not required.
Not required. Good.
Hello.
Item 5.
With Lordship permission, I beg to withdraw this matter with a liberty to file a fresh.
Okay, well, if you want a liberty, you will have to tell us why.
My lord, there was some problem with the translation, my lord. a bona fide mistake has happened. So we'll file it afresh, my lord.
So we permitted you to file an additional affidavit. No.
But we'll file it afresh, my lord.
Okay. Upon instructions, Mr. A.W. Aman, counsel for the petitioner seeks to withdraw this petition with liberty to approach again as there are certain certain no, that's some incorrect translation has been brought on record. Mr. J. Pang, Leonard, standing counsel for the FT matters, Mr. M. Kalita for respondent. Mr. M. Kalita, Leonard counsel for respondent number 2, and Mr. R. K. Talukdar, Leonard counsel for respondent number 4 are present. Next paragraph. Matters is dismissed on withdrawal with liberty as prayed for.
Grateful, my lord.
Item 6.
Yeah, please, your lord. Lordship, here the arguing counsel is out of station, your lordship. This matter may be passed over for the day.
You are not in the matter.
No, your lordship.
All sides are represented on the prayer made on behalf of the Learned Counsel for the petitioner. Matter stands adjourned today. List of
Can this matter be
Vacation.
fixed on 4th? On 4th?
Pardon me?
On 4th, can this matter be fixed on 4th?
4th will be last day of the court. We are not fixing it that day.
After vacation.
After vacation, of course.
Keep the
Item 7.
May I please, your lordship? My lord, the petitioner in the incident case, initially he was declared to be a foreigner by the Foreigners Tribunal, my lord. Accordingly, he approached before this honorable court, my lord, challenging that order, mainly on the ground that, my lord, his own brother has been declared to be not a foreigner by the tribunal, my lord. And that document, that order, although he exhibited during the procedure in the before the tribunal, there was no discussion regarding that order while passing the judgment and opinion against the petitioner, my lord.
This is the opinion.
That initial opinion, my lord.
No. The present challenged opinion.
Present opinion, my lord, at page 56, annexure 11, my lord.
Why do you say there is no discussion? Para 12, there is a discussion.
No, this is after remanding of the matter back by the Honorable High Court, this opinion has passed, my lord. In this, but in the earlier opinion, there was no discussion, my lord. The earlier
We
opinion,
are now on the present opinion.
yes, my lord, that is 56, my lord. Para 11. In the earlier opinion, there was no discussion, my
How
lord.
is it relevant now? The discussion that not being there in the earlier opinion, how is it relevant for the purposes of the present opinion? You are challenging which opinion?
The present opinion.
So present opinion, there's a discussion at para 12.
Yes, my lord.
So why did you refer that there was no
My lord,
discussion?
just I am trying to make the submission how this has come, my lord, because it is the second opinion, my lord. And here, my lord, in this opinion, the earlier exhibits, my lord, those has been also discussed, my lord.
Is your evidence?
Evidence, my lord, I have evidence of his brother or my evidence, my lord.
No, no, we want to see evidence adduced in respect of exhibit L.
Yes, my lord. My lord, that is, we have filed an one additional affidavit, my lord. Your lordship will find that page, my lord, 67, my lord.
It was filed by the brother.
Yes, my lord.
But Mr. Bora, what is wrong in that? You come to your additional to this additional evidence,
Yes, my lord.
and please come to this exhibit L.
Yes, my lord.
This exhibit L, is that page?
Page, my lord, 32, my lord.
32.
Yes, my lord.
Yes. You read this order, opinion.
Yes, my lord.
This so and so, alias so and so, and alias so and so is not there in that exhibit L. You are using two alias.
Yes, my lord. Abdul Salam.
That Abdul Kalam is not there in this page 32. What is
Abdul-
wrong in this opinion?
Abdul Salam, my lord. Abdul Salam.
Yes.
Yes, my lord. The name of the opposite party in order at page 32 is Abdul Salam, my lord. And this DW3 is also Abdul Salam, my lord. Abdul Salam alias Abdul Salam. And father name is also same, my lord.
Where is your evidence on affidavit?
My lord. My lord, my evidence is not, has not been annexed, my lord, but the exhibits, my lord, documents I have annexed, my lord.
No, you see, the finding of the tribunal is very specific,
Yes, my lord.
that in your evidence, you have disclosed about Abdus Salam, ABDUS.
Yes, my lord.
But the opinion is the name of Abdul Salam versus Muhammad Abdul something.
Yes, my lord.
So these are the two names. So the third name is extra.
Yes, my lord. And in the DW3, my lord, the evidence in chief, my
No,
lord.
no, he can't give evidence better than you. You introduce only one name.
Yes, my lord.
Now the witness who comes, he gives three names. He gives a better evidence than you.
Normally, the last word, Abdus and Abdul, my lord, because in the footer list or in other documents, his name has appeared sometimes as Abdul and sometimes as Abdus. But the father name and residence, all are same, my lord. Father name, residence, all are same. And the Jomabandi copy, if your lordship see the vital document, my lord, at annexure 2, page 21, my lord. The vernacular portion, if your lordship takes at page 22, my lord.
Yes. Entry number?
9, 10, 11. 9 is the petitioner. Hatem Ali, son of Meser Ali. And 11 is in the short form, Sri A Salam, son of Meser Ali. And in the remarks, my lord, it has been specifically stated that as per the order of the circle officer dated 2/4/2009, the names of Hatem Ali, Hamed Ali, and Abdul and A Salam are mutated instead of Jamiran Nesa by virtue of inheritance. And the name of the father of the petitioner, my lord, his name was mutated in the year 1966, my lord. The initial remark, my lord, at page 22. The very first remark, my lord.
We will call for the records at this stage.
Yes, my lord.
Mr. Pai?
Yes.
Heard learned counsel.
And my lord, interim may be considered at this stage. He is an old person, my lord.
Issue notice. 2019 matter.
My lord, what happened actually in the year 2019, my lord, because the petitioner told that, my lord, he handed over the brief to someone to approach before the.
This is.
Yes,
this
my lord,
is-
I understand.
This,
If your lordship.
this ground is not
Yes, my lord,
acceptable
if your
until and
lordship.
unless you array the, if you take any steps against the concerned lawyer, that's
Yes,
a
my lord.
different.
No, I understand. But if your lordship prima facie satisfies with the materials, my lord, then your lordship may consider the interim. Because my lord, the Jomabandi, my lord, there is only discrepancy regarding the last word, only
All right,
one letter, my.
before the court proceeds in the matter, we would like to examine the tribunal records. So, registry to call for the tribunal records relating to FT case number 178 of 2016 from the Foreigners Tribunal number 4th, Borpeta. Stop. The matter be listed after receipt of the records. Matter be listed after 3 weeks upon receipt of the records. Stop. We pray for interim will, oh, he's already detained.
Yes, my lord. Recently, my lord, on 7/8/2024, my lord.
What about the IA?
IA
The
is
issue
praying for,
notice.
stay of
Notice may
the,
be issued in this case.
Right. This is in the writ petition, then in the IA 30984. This IA has been filed, see, by the petitioner, praying for release from detention. From the detention center at Motia in the district of Gwalpara. Stop petitioner was detained in terms of the detained on 7/8/2024. In terms of the order dated 28/02/2019 passed by FT, passed in FT case number 178 of 2016 by the learned member Foreigners Tribunal 4th Borpeta. Stop issue notice. Mr. K.K. Parasar appears for the respondent number 1. Mr. J. Payeng for respondent number 2, 3, and 7. Mr. Talukdar for respondent number 6. Mr. Kuli for respondent number 5.
M. Kalita. M. Kalita.
M. Kalita for respondent number 5. The respondents are permitted to file their objections, if any, in the meantime. This IA be listed along with WPC 4223. Without, it is provided that in the interim, petitioner shall not be deported out of the country without leave of the court.
Item 8.
May I please your lordship?
Yes.
Lordship, in this case, ex parte order was passed, my lord. And, this case. Petitioner in this case has been regularly cooperating, my lord, but last 2 occasions she and her engaged counsel was not present, my lord. Order sheet may kindly perish that page 59, my lord.
59.
59 of the writ petition. In this on 1/11/2022, strictly, my lord, information was given to the petitioner as well as the engaged counsel. And next date was fixed, my lord, at page 60. And where ex parte order was passed. Otherwise, petitioner regularly appearing, my lord. Due to some mistake, my lord, and communication was not able to done, and the engaged counsel actually was not informed about the date, and the engaged counsel himself was not about.
No, you have failed to show that he was regularly appearing. You said that he is regularly appearing otherwise. That otherwise regularly appearing is
My
not there.
lord, sometimes she was absent, but in the last occasion, my lord, the ex parte order was passed. It is not a fact that present petitioner was long days she was absent continuously. She was absent. It was.
You want us to admonish the this Foreigners Tribunal for delay in passing ex parte order?
My lord.
You want us to admonish the tribunal for not passing order earlier? He waited for 19 days.
Right. Lordship, as per
You want us to express our displeasure against Foreigners Tribunal 11 for waiting for 19 days.
My lord, 90 days, it is, date was taken, my lord, without assailing the good reason, my lord. And proper reason, just the present petitioner submitted all the relevant documents and WS was filed, and thereafter all the dates was fixed for evidence slash argument, my lord. But there is no any new development that the petitioner will submit new documents, new evidence,
No, but you see, you have written in page 12
my lord.
that you took the advice of your counsel not to appear before the tribunal. You are justifying it. You are not showing an explanation. In page 12, you are justifying not a non-appearance. You said that your lawyer said don't appear and you are stopped appearing. How can we
Sometimes
accept that?
it was covered, sometimes
No, we don't know. Please read and tell us. We are showing you page 12.
Page 12, my lord. The OP from page 12, my lord.
Oh, you will read it now.
My lord.
No, don't read now. You should have read it at home. If you read now, nothing will happen.
My lord, the present petitioner.
You see, if in page 12 you are writing that your lawyer told you not to appear and you stopped appearing. So this is a justification not to appear.
Particular next date, my lord. Informed not to be appeared, and engaged counsel will take a step, my lord. I supposed to mean that.
I don't know, whatever you have explained, we are trying to understand.
I trying to submit, my lord, that on that specific date the engaged counsel was informed not to be present.
You read page 12. You read and tell us whatever you have written. Moreover,
Maximum date OP was
not
instructed
maximum.
by
Before
the
that, you
council
missed
not
out
to
one
be
line.
present. Those dates the OP was absent, my lord. Sometimes it was long dates the case was
We are
running,
asking
my
you
lord.
to read whatever
My
you
lord,
written.
maximum date OP was
No,
instructed.
kindly read from the beginning of the sentence.
That the proceeding further begs to state that the engaged counsel, after taken 19 dates, after filing WS, maximum date was not informed the OP. Moreover, maximum date OP was instructed, oh sorry, your lordship, instructed by the council not to be present in the tribunal. Maximum date the engaged counsel was also absent without having knowledge of the next fixed date, and hence it is clearly proved the negligence on the part of the council, my lord.
Then what steps have you taken against the council?
My lord, steps has taken, my lord.
What?
In page 76, my lord. 76, my lord, the hand note, my lord, given by the engaged counsel. It was two types of wrong has committed. Adjournment, several adjournment has taken without assailing good reason. And after pass the ex parte order in 2023, that was not disclosed. And another contact was done that matter has to be filed in the High Court, but not the matter was filed in the High Court. And when the police searching the petitioner at their home, then comes to knowledge that no case was filed, my lord.
You're wasting time.
My lord,
Don't
here,
start questions of the court.
my lord.
When we are asking you something, you either give a reply or take time to complete your instructions. Don't try to skirt the questions of the court. You are blaming it on your lawyer. What steps have you taken against the lawyer?
My lord, the complaint has filed.
Where?
Before the bar council
Where
in
is that complaint?
at page, my lord, 78, my lord. At page 70.
What orders have been passed?
The notice has communicated, my lord, from the bar council, and the
You are half-hearted. If you file a complaint before the bar council, you will get you will have to pay some fees. You get a money receipt for payment of
my lord,
fees.
I have the money receipt. Last time I was submitted and order was passed, my lord, and fixed for along with the LCR, my lord, for today. I have the copy original money receipt, my lord. Last time I was submitted for the board.
You see, you have uh, you are perhaps presupposing that we have not read it, uh, read the brief. In your complaint,
My lord.
that in your statement here, you have written somewhere that in the High Court, bail was not taken.
Bail means in the lower court.
We don't know. You see,
My-
you don't explain that. Somewhere you have written that no bail was applied.
My lord,
And now when you come to this complaint at page 79,
my lord.
you don't say about bail. You conveniently change it. You say that,
My lord,
sorry, page 80, you just say that hence after practicing lawyer verified comes to know that no case was filed. So this bail is now changed to case.
My lord, bail means the interim protection. The lower court as usually used for bail, my lord. In the high court, it is some different meaning, but they as usually used for bail, my
No,
lord.
when we are
Commonly
reading in High Court, we understand what we read.
Bail means interim protection, my lord, here.
If without an appeal, how can an interim protection be
That
granted?
the engaged council was done the deal to file a writ petition after pass the expertise order, my lord. And that writ petition was not filed, my lord. Writ petition bail means for the interim protection, my lord. But that writ petition was not filed. And therefore the case was delayed, my lord.
You mentioned here is not filed a bail petition.
Bail, my lord, normally it is used, my lord. As per my knowledge, the lower court advocates, they are usually used this word, that bail, regarding the interim protection.
No, perhaps you don't know. I was also a trial court lawyer.
My lord, you obliged, your lordship.
But
But-
I never used for every petition, I would not use a word bail. I am also I was a trial court lawyer.
But the tribunal related matter, they used as bail, my lord, because when the party appeared before the appropriate authority, they granted the bail. And
No, don't tell
Yeah.
us those things. Then we'll have to have a dictionary made and what terms are used in the tribunal. We don't want all those things to be done.
This thing written by the council, my lord, and at least we have his negligence he has proved, my lord, and uh, therefore the present petitioner by bound she has filed this complaint, my lord, without having an alternative way, my lord. And as being the illiterate, my lord, they have no any knowledge regarding the proceedings, my lord. At least she has sufficient documents, my lord. Kindly may for on any condition, my lord. Because for the wrongdoing of the on part of the council, she regularly, my lord, as her tried best to cooperate to complete the proceedings, my lord. So much dates has taken. It is admitted fact, my lord. From 2018 to 2023, my lord. Even COVID period, 2 years COVID period is over. Not a single date was taken in the name of the COVID, my lord. And procedure was cooperating, my lord. And evidence part is not over, my lord. So kindly may considered, my lord, for the interest of justice. Otherwise, for this petitioner, she has some child and school going children. All family will be suffered, my lord. And it is not a fact, my lord. Long days she was not absent, my lord. On any condition, your lordship kindly may grant it. My respectful submission, Your Lordship. Maximum dates she was cooperated, my lord. And maximum dates was taken without informing the proceeding, my lord.
15 to 19. 15 to 19. Equal to this. 19. Nineteen. What is the date of the opinion?
My lord, 20. My lord, 3/12/2022, my lord.
3/12/22.
My lord.
No, then you don't succeed. We'll send you the tribunal records. You don't succeed then. You'll have to dismiss your petition.
My lord, here my
No, your statement appears to be false. At least your instructions can be false. You're not your statement, but your instructions can be false.
My lord, as per
Yes. Now, Mr. Pang and you both check this record. I put a flag here. From there till the date of 1/10/2022. Your presence is recorded.
my lord.
You were before the tribunal. There are two flags I put. So it's not a case that you have no knowledge of the date. We'll have to take it up some other day. There's a,
Yes.
we have to go. There's a meeting call. The one matter, Mr. Khan. Right, take up your matter tomorrow. Mr. Khan.
Item 18.
Item 18, just after. You will take these matters and their IA tomorrow.
Yes.
You take it up tomorrow on these matters. It is order for extension of time.
Item 27 also.
And you see this record, the story apparently doesn't match. He is present all throughout.
Yes. Item number 14.
Just we will have to rise. There is a meeting.
Yes.